Like, share, subscribe. Shouts out to the Lions Den community. And don't y'all forget to subscribe to the podcast show. Link will be pinned in the top of the chat.
Just name the channel who could bang with us. I'll prove that you are smoking dust. GTV Media is top notch in this game, y'all. You failures only have yourself to blame, y'all. Ticket TV and a weapons make you suckers cry. Why don't you close your channel, crawl into a hole and die? Shout out to those who love our movement, no, we'll never flop until you get your mouth on LGBT. We are the underground outfit, y'all. We built this whole thing by ourselves, look in y'all. Independence start with self-preservation. If you can't take care of self, then how can you build a nation, y'all? Yeah, we got that merch for the ladies and yes, we even got that merch for the babies and we got appliances and everything that you will need. We got some banging songs that make anemic haters bleed.
All right, you guys, so salute everybody as y'all tap on in. Like, share, subscribe. If y'all can hear me, press 2 in the comments, man. Let me get a mic check real quick if you guys can hear me. Press 2, and let me get a mic check real quick to make sure that you guys can hear me in the comments. Salute to all of you guys. Appreciate everybody that's going to tap in. Y'all know what's up, man. Can y'all hear me? Y'all can hear me? All right, man. So basically what's going on is we're going to go over what happened with this Tupac Shakur murder court hearing that Duane Keefe D. Davis's lawyers have requested. Basically, Duane Keefe D. Davis has been arrested for the murder of Tupac Shakur, and he is being retried based off of, from what I can gather, self-incriminating statements that he made in interviews on YouTube. Ever since he gave that proffer agreement. And so, that charge has now come to his front door and is now sitting on his front step. Keefe D is arguing to the courts, and we're going to tap in. He's arguing to the courts that this is not just, that all the other parties that were involved in the situation are deceased, they're no longer alive, and that he is not subject. Again, he's saying he is not subject. He is not basically should not be implicated in this murder because the jury should not be able to use his words against him, being that he's saying that it wasn't true, and that if it was such an issue, why, when he gave these statements years ago in a proffer agreement, did they not want to arrest him then? So we're going to get into this court hearing, listen to some of it, and then break it down real quick. Let's get to it.
All right, let's get to page 10. Does anybody have anything they want called signal complaint before we get into the data?
So the first thing, my bad, I want to say this to y'all too. The first thing that's going to be stated is that the first guy who's going to speak is actually Keefe D's lawyer. So Keefe D's lawyer is going to speak first. So we're going to hear Keefe D's lawyer speaking now. So let's get to it.
That's the sheriff being found a case, and the law is very clear that you cannot have just the confessions, because if you just leave that to the jury is going to just assume guilt because he confessed. And so without the state providing any evidence outside of those confessions, that's a huge problem. It amounts to a legal trial, a trial that won't have the correct result. And so the state is saying that basically we were, we should have done this as a habeas petition. I disagree with that. Here's the reason why. We are not contesting probable cause. What we're contesting is, after all of the evidence has been delivered, there's no corroborating evidence. There's nothing. And then the state also stated that we're just looking for a corpus delicti. You just have to look at the body. If there's a body, there's corpus delicti. And that's just not the rule, Your Honor. there has to be, obviously in this case, a body. But the state has also alleged that this was assisted, promoted by a gang. And so those facts have to be evident. And the only way we have those facts is from Mr. Davis's own mouth. The other participants in this, which I'll talk about in my second argument, are all dead. And so, but for Mr. Davis speaking and giving those statements, there is no corpus delicti in this case. I'll go to argument 2. And that's Mr. Davis's right to a fair trial and due process. The state pointed out the correct standard of review for that, and I don't disagree with that standard. However, the part that we disagree with is whether Mr. Davis is prejudiced or not. They're saying, well, the witnesses that died are going to give speculative as to what the witnesses would say. In those cases, yes, that would have been the situation. In this case, it's different. I'll just concentrate on these 4 witnesses. Eric Martin, and just for the court's edification, Eric Martin was the person that supposedly gave the gun. DeAndre Smith, who was in the backseat. Terrence Brown, he was the driver, and Orlando Anderson was alleged to be the actual shooter. Without these 4 co-conspirators being alive, being available at trial, basically, Mr. Davis is completely prejudiced from proceeding. And his defense is he made this all up for profit. These individuals, these co-conspirators, have to exist in an effort to kill Mr. Tupac Shakur. If they're not alive, if Eric didn't give him the gun, if DeAndre wasn't the driver, if Orlando didn't shoot, we don't have a murder, according to the state's theory, which is following, again, solely the omissions. So we go back to when was this information available to the state? I would allege that it was available all the way in 1996. Everybody knew Orlando Anderson was in a fight with Tupac. Well, he wasn't in a fight. He got beat up by Tupac and other members of his gang viciously. He was the #1 suspect right off the bat. There should have been an alert. The police should have been searching for Orlando Anderson, but we always knew where he was because we went back to LA. They could have been in contact with him. They could have gotten statements from him. They could have gotten statements from Mr. Davis. They could have gotten statements from Mr. Martin. They knew all of these players way back in 1996. I don't know what happened. I'm sure Mr. Giacomo doesn't know what happened in regards to why the district attorney's office did not proceed with prosecution or at least an investigation at that time. But it's a tactical delay that goes severely against my client because now all of these players are dead. I'll fast forward all the way to 2009. In 2009, the Metro officer comes down to LA and gives us, Mr. Davis gives the statement. That statement, all of the elements of this murder and what the state will attempt to prove at trial if the trial goes forward, is what Mr. Davis has said. They had that information. They did no investigation. At that time, Eric Martin was still alive, and also Terrence Brown was still alive. Orlando had passed in 1999. I think DeAndre Smith in 2005. But at least 2 major players in this co-conspiracy are passed. The DA's office, again, does not do any investigation beyond that. And so, with that, we feel that my client's sufficiently prejudiced beyond repair. It leads me back to the immunity argument. In 2009, I counted, well, I'll just go through the pages, Your Honor.
Now, basically, let's break this down real quick. Y'all smash the like button as y'all come on in here and subscribe if y'all not subscribed. Basically, they're saying that, they want this case dismissed and thrown out today because they're saying that, hey, man, there ain't no evidence. You guys are just using his statements. Now, some people can say, hey, look, you made these statements under a proffer agreement in which you thought was, airtight, meaning that you could confess and they couldn't charge it against you. But there is rumors that only extended to that, session, that if he made more confessions outside of that, then it could possibly be used against him. Now, again, we don't know if there's any new evidence in this case or what they have to, hold Keefe D in jail right now, unless it's just his statements in different interviews. Keefe D did multiple interviews on social media, basically confessing about the murder of Tupac Shakur, and also, implicating and stating who else was in the car allegedly with him. But now he's, basically trying to use in court that this is all cap, and that's not what it is. But they also had papers. I told y'all the other day that said that at the time he had named Diddy, I guess 40 some odd times in his statements, and tied him uh, to basically offering or saying that he would offer millions for the unaliving of Tupac Shakur and Suge Knight. So now they're in court, and they're trying to see right now if they can get this case thrown out, because they don't think that the prosecution has evidence to prove that Keefe D, and I'm talking about physical evidence to prove that Keefe D, unalived Tupac Shakur, or was even, at that situation as he said he was. My thoughts is this: I don't know if they're going to then go back and say, well, hey, well, then his proffer agreement is no good because he was supposed to tell the truth under the penalty of perjury. And so if that's what he said in the proffer, and then he came outside of the proffer in different interviews and said the same thing again, now what's the situation? Now his lawyer is going to break down a few points right here. And I want you guys to specifically listen to these points his lawyer is going to break down. And y'all smash a like button and subscribe as y'all come on in.
In that 2009 discussion with the Las Vegas Metro Police Department officer, Detective Long, on page 3, he says, no intent of arresting Keefe. Page 11, I'm not here to arrest you. I'm not here to arrest you. I'm not going to arrest you. Page 12, you're free to leave. I'm not going to arrest you. You can go wherever you want. Page 103 and number 4, Terrence Brown was still alive, and the detective said, I was not going to arrest him. Page 134, I want to close the Tupac case. Page 138, this is confidential and covered, and you cannot be charged on it. Basically, you have the state was given the information by the LAPD. The LAPD had a immunity agreement with him out of the 2008 confession. The 2009 confession came by a product of Detective Dupree. Detective Dupree set that up. The only reason he set that up, and why my client would have agreed to, was that everybody was on the same page, that immunity was going to be provided. If it wasn't, how come he wasn't arrested right then and there? Because he said, I got the gun from Dick Martin, we were in a white Cadillac, I handed it to the back seat, and then Orlando took the gun and shot Tupac. All of that information is back there in 2009. But again, the DA office, and again, it's not these players, it's not Mr. Wilson or Mr. Giacomo. That decision was made back then not to proceed with the trial. And now it's the state's burden, we believe, to show why they did not go forward and prosecute. They just can't sit here and say, well, he kept talking about it. No, you had that information in the beginning. You should have arrested him back in 2009.
Now, see, that's the thing. And see, this puts a bind on it right here, because his lawyer is cooking, right? But here's the problem. And this is why I think they're going to try to get Keefe D. And this is the issue right here. I think that what's going to happen is they're going to try to say, hey, look, his proffer agreement was only for that session. His proffer agreement wasn't for him going on interviews outside of this proffer and then speaking on this outside of this certain agreement. So if let's just say he says some things in a proffer and then the proffer agreement is done, you should leave that alone. But if he goes outside of that proffer agreement, is what I'm thinking that the prosecution is saying, and basically admitting to involvement in the unaliving of Tupac Shakur. Oh, okay, well now that's called self-incrimination. That's called self-snitching. So what they're doing is, I think, in part, is using that, And then again, I don't even know if they can use the statements from the proffer agreement because they were in the proffer agreement, but they're being brought up in court. So it has to be relevant because those statements are being brought up in court. But his lawyer is saying that, look, they knew all of this back then. And his lawyer's bringing up a solid point right there. They didn't even arrest him back then. So if he told you this back then, but see, that was because probably they wanted some other information on something else. So, sometimes you have these agreements worked out to where, hey, you give me something and hey, look, we'll lighten up something over here. So, that's what I think this whole situation is based off of is that, Keefe D gave some information, in my opinion, in the proffer for them, what I'm saying, to, spare him on something else. But now, since Keefe D went after that and did these interviews on social media, basically, admitting to involvement in the unaliving of Tupac Shakur, now they're coming back and they're saying, oh, well, I mean, this guy's walking around basically saying he was in on it. He was there. So now they went and picked him up. Now we don't know in the general public if that's their whole case or not, because the evidence has not been laid out yet. But the way Keefe D's lawyer is talking, that's all they got. Is that Keefe D's in interviews saying that he had involvement in the unaliving of Tupac Shakur. So let's get back to it.
You just can't sit here and say, well, he kept talking about it. No, you had that information in the beginning. You should have arrested him back in 2009. And so it has to be for a tactical advantage. That means everybody's dead. It leaves Mr. Davis on the hook, and then he can't answer for all of the statements he made after that, other than it was for profit.
So, regarding the timeline that you laid out,
that's right.
Mr. Martin and Mr. Brown have been alive after the Compton Street legend book was published or not?
What is that, 2018, right?
2019, no. Terrence Brown dies, I believe, in 2015, and just Martin, I don't recall exactly when he died.
But it's not the argument that he ultimately would, if that's the state triggering event for starting to investigate, that he would not have been alive at that time.
After the book, right, when the book was published.
Yeah.
But after the 2009, he was still alive.
Of course, that's a long interview, of course, they're still alive, but except for the spring understanding. Okay. I just wanted to make sure I had it.
Yep. And outside of any other questions you want to submit?
Okay, thank you, Mr. Arnold. Mr. Bujado, anything you want to add?
Just briefly, as it relates first to...
Now, this is the prosecution that's getting ready to talk. Now, the prosecution, and y'all hit the like button as y'all come in here. The prosecution is getting ready to lay out, why this case should go on. And then the judge is going to rule. Let's get into it. So let's break this part down right here.
That's by criminal agency. Obviously, Mr. Shakur didn't shoot himself. So that is satisfied in a homicide by proof of the facts and circumstances which were testified to by the grand jury. And it is an argument. We didn't go through all of the evidence that's potentially out there. Their argument is there was insufficient evidence presented at the grand jury in order for them to be held under the corpus delicti rule. Even if you were to take it a next step further and say you have to have some evidence of a conspiracy independent of the bullets in Mr. Shakur, there's clearly at least a driver and a shooter, so evidence of a conspiracy exists. And so therefore, corpus delicti is satisfied no matter how you look at it, one way or the other. I also would dispute that there's no independent evidence to corroborate, but that's not relevant in a corpus delicti argument. Corpus delicti is about criminal agency, and there's clearly criminal agency in this particular case. As it relates to the second argument, I'm unclear exactly what their argument is on the tactical decision we made. Their argument is he fully confessed, which, as the court reviews that transcript, you can tell that he is being a knowing spectator all the way up until Dan Long gets kicked out of the room. Then his lawyer and Detective Dupree have a conversation where his lawyer tells him, hey, if you say the wrong thing, this guy can arrest you. And as you well know, because they're in California, Dan Long can't arrest him. Dan Long has to come back here and submit a warrant for his arrest and take him into custody. Detective Long never tells him that he has immunity, but even if he did, all that would go to is the admissibility of the statement. Because Detective Long doesn't have the authority to issue that, nor do the LA DAs or the LAPD.
Man, that's some dirty shit if that's true. Hold on, y'all. Y'all smash the like button. Did y'all not hear what he just said? He just said that the proffer agreement, he said that the officer had no authority to give Keefe D the proffer agreement. And that Keefe D's lawyer told him at the time that if you make this statement, they can arrest you right now. So bro, so listen, here's the thing, right? If that's the case, and Keefe D can prove that he was lied to, he may have a lawsuit, but he may have to serve it in prison. He may have a lawsuit. If Keefe D was lied to by police who investigated him, and they told him, "Hey, man, the statements you make right now can't be used against you in court." But it can. Shit, he can prove that. He might have a lawsuit, but then he's still going to end up in prison. Because if what the prosecutor just said was true, and this is what the prosecutor just said, Keefe D is screwed, in my opinion. Because if you admitted that, and that's the reason why, him talking like that, bro, if you admitted that in an interrogation room, and you didn't have in paperwork that the statements that you made cannot ever be used against you in any court of law, man, bro, I'm telling y'all right now, bro, this is curtains right here. The prosecutor just said something, and he just revealed some shocking information. He just said that the officer didn't have authority to give no proffer agreement to Keefe D. Meaning that he didn't have an authority to give him an agreement to where if he confessed that he wouldn't get charged. Lord have mercy, man. And Keefe D might not have known this the whole time, man. Man, bro. Listen to this, y'all.
Oh, Dan Long can't arrest him. Dan Long has to come back here and a warrant for his arrest and take him into custody. Detective Long never tells him that he has immunity, but even if he did, all that would go to is the admissibility of the statement. Because Detective Long doesn't have the authority to issue that, nor do the LADA or the LAPD or the federal government. Only a court in the state of Nevada could say Mr. Davis has immunity from the crime of murder in the state of Nevada. And he has pointed to zero evidence whatsoever of any immunity. He has referenced some proffer agreements that he had with other agencies. And certainly that could be the subject of future litigation as to which of those statements are admissible or not admissible. And then the other, argument is somehow we waited intentionally so everyone else would be dead to charge Mr. Davis with a crime. No, Mr. Davis chose upon himself to publicly confess to a crime multiple times. And that's the evidence that spurred the investigation of Detective Long and ultimately resulted in his arrest.
Damn, shucks, they got him, bro. This is crazy, man. So they're saying his testimony can and will be used against him now. That him going and doing those interviews and saying and then confessing to participation in the unaliving of Tupac Shakur had reopened the investigation, and that's why he's been arrested, and that's why he's being tried for the murder of Tupac Shakur, man. That is crazy, bro. So they're saying that the people who alleged that he had a proffer didn't even have the authority to give him a proffer agreement. So this dude, Keefe D, may have gotten all the way lined up, man. And this might be happening from not reading the fine print, if that's the case. Because if you didn't get that on paper, if they didn't give you an agreement on paper that was stamped, signed, and sealed, that told this dude that, hey, anything you say in this room cannot, will not, or shall not in any court of law be used against you at any time. I don't even know if Keefe D signed the paper, bro. And when Keefe D did those interviews, bro, oh my God, bro. When he did those interviews online, bro, this man might have put himself in prison for the rest of his life. Because the prosecution is coming in that John Stern. He says, man, ain't nothing that they told. He said the guy, they don't even have the authority to give him. They don't even have authority to give him a proffer agreement. Think about that now. They say they don't even have the people who gave it to him, they say they don't even have authority to give him a proffer agreement. And he also said this man confessed to an open murder. He confessed to an open murder. How is he immune from prosecution? When the people who he claims gave him a proffer don't even have that authority to do it. Man, Keefe D he is getting hit 3 the hard way on this one, y'all.
Mr. Davis has no basis to complain that he's sitting in that box right now. Because Mr. Davis, to publicly confirm Mr. Davis.
He cooking. Hey, yo, real talk. I ain't gonna lie to y'all, man. The prosecution cooking this dude. And I'm gonna tell you why, bro. Keefe D went out there talking in them interviews, man. He went out there talking in those interviews, man. I be damned, dog. Listen to what he said, though, bro. This dude was talking in them interviews, man. They lined him up. It's a wrap, bro.
Was a crime. No, Mr. Davis chose upon himself to publicly confess to a crime multiple times. And that's the evidence that spurred the investigation of Detective Mogg and ultimately resulted in his arrest. Mr. Davis has no basis to complain that he's sitting in that box right now. Because Mr. Davis got up there and even quote once said, I think it's in May of 23, on video, I beat the streets, I beat the feds, and I beat cancer. That was his choice to make. And when he made that.
See, and this is the reason why I try to tell y'all this, man. You guys don't never, ever listen, bro. Bro, you go on interviews with the Culture Vulture talking about open murders and stuff like that. Bro, I'm telling y'all this, man. I'm telling y'all this, bro. The feds is watching, bro. Them people watching, bro. Them people watching, man. I'm trying to tell y'all this right now. They watching, bro. This man quoted Keefe D's quote verbatim from that interview, bro. And when they say that in court, when they say that in open court, with that quote he put, and you better believe they're going to use the interview. They've already got that interview where he said that. They're going to use that interview, bro, where he said that, and they're going to play that shit in court. And that's going to put him in prison for the rest of his life, bro. I'm telling you, bro. They're going to put this case on him. In my opinion, they're going to put this case on Keefe D, man. You know what I mean? They're going to put this case on Keefe D, bro, in my opinion, bro. Listen to what he said, bro. They listen to all that stuff he said in them interviews, bro. And now they're using it against him.
His arrest. Mr. Davis has no basis to complain that he's sitting in that box right now. Because Mr. Davis got up there and even quote once said, I think it's in May of 23, on video, I beat the streets, I beat the feds, and I beat cancer. That was his choice to make. And when he made that choice, the Santa Nevada chose to charge him, and he needs to stand trial for the charges, and I'll submit it.
Well, he said Keefe D did it to himself. He just told y'all. The prosecutor just told y'all when Keefe D said what he said in that interview, they came back and got his ass. I'm probably gonna let Keefe D ride, and that's the sad part. You had a situation that happened to Tupac Shakur. They probably was gonna let the thing ride, and because Keefe D, from what they're saying, couldn't keep his mouth shut and said that he beat the feds, he beat this and beat that. They said, okay, let's go pick this guy up. That's exactly what the prosecutor just said in open court, bro. He said that's why we went and picked him back up. Not because, think about this, not because we wanted justice for Tupac Shakur. No, they didn't say that. They said we went and picked him up because of his big fat mouth and what he said about beating the feds. I'm trying to tell y'all this, bro. That's why I said, when you go talking about open murders on interviews, bro, the feds is always watching, bro. The feds is always watching. That's why I'm telling y'all. That man, listen to what he just said. He said, because Keefe D said that, basically he's saying, because you stuck your nose out at us, because you was out here walking free, that's why we went and got you when you said that. They didn't say because we wanted to solve the murder of Tupac Shakur, we love Tupac. Didn't Kading and them say they already had this case solved a long time ago? So why wasn't any of those guys arrested? Maybe you think they didn't want to solve that. Is that what you think? They didn't want to solve that?
That choice, the Santa Nevada chose to charge him, and he needs to stand trial for the charges, and I'll submit it.
Let me play that one more time.
Somehow we waited intentionally so everyone else would be dead to charge Mr. Davis with a crime. No, Mr. Davis chose upon himself to publicly confess to a crime multiple times. And that's the evidence that spurred the investigation of Detective Mogg and ultimately resulted in his arrest. Mr. Davis has no basis to complain that he's sitting in that box right now. Because Mr. Davis got up there and even quote once said, I think it's in May of 23, on video, I beat the streets, I beat the feds, and I beat cancer. That was his choice to make. And when he made that choice, the state of Nevada chose to charge him, and he needs to stand trial for the charges. And
when he made that choice, the state of Nevada chose to charge him. He said, man, hey, Keefe D is in jail right now, facing the rest of his life in prison because of his own statements. The prosecution just said it in open court. They said because of that interview. So can't nobody else say that, oh man, they ain't get locked up for no interview on my channel. The prosecutor just said because of that interview, where Keefe D said what he said in that interview in May of 2023, that I beat the feds, I beat cancer, I beat all this. He said they decided to charge his ass. Not because they wanted justice for Tupac. Think about that now. They did that just because they said he stuck his nose, he stuck his two middle fingers up at him. Say, yeah, I beat y'all. No, you didn't. Come on back in here, buddy. That's what they said. And they used that interview. I told y'all this. They used that interview. Well, you got an open murder against him. Listen to what he said. The prosecutor said it wide open.
Mr. Davis was a crime. No, Mr. Davis chose upon himself to publicly confess to a crime multiple times. And that's the evidence that spurred the investigation of Detective Mog and ultimately resulted in his arrest. Mr. Davis has no basis to complain that he's sitting in that box right now. Because Mr. Davis got up there and then even quote once said, I think it's in May of 23, on video, I beat the streets, I beat the feds, and I beat cancer. That was his choice to make. And when he made that choice, the state of Nevada chose to charge him, and he needs to stand trial for the charges, and I'll submit it.
Yeah, just a quick rebuttal. I don't want the court to get hooked up on this corpus delicti. The corpus delicti rule is basically, again, that's in the preliminary hearing stages of the case. The black letter law is this. The law states you cannot have a conviction based upon just his admissions and statements. That's the law. If the state at this point puts on a trial to a jury and that's all they have is his admissions, that whole trial is illegal. That's a legal trial. It's going up for appeal. It should not happen. They need to have something else, a gun, a witness, something else that puts this gentleman, those three co-conspirators in the car. They need to have a witness to say that the gun was given to from Mr. Martin to Mr. Davis. They don't have anything. They don't have anything to even prove that my client was in the state of Nevada at the time of this incident. I mean, basically, they have Orlando Anderson, but we don't know if the Crips were here. That's all hearsay that came from the grand jury, and there's no evidence whatsoever. And so without that, we can't put on the trial, Your Honor. We just simply can't. In regards to the delay, again, I don't blame this office, this DA's office, in regards to the delay, but somebody made the decision along the way that we are not going to prosecute Mr. Davis. And this office now needs to go forward with that immunity agreement. They need to. Those promises were made by their officer, the state's officer, and now we're just going to ignore that? That doesn't make sense.
Immunity agreement from this office, or from the general...
From the general immunity that started from 2008 and went to 2009. Like I said, the only reason that...
Who within Clark County DA's office made that argument? Who was that?
No, it wasn't at the DA's office. It was the Las Vegas Metropolitan Police Officer, Detective Long.
When he said things like, I'm not going to arrest you.
Right. And again, like I said, it was not the office. And so outside of us, having an evidentiary hearing as to who made those decisions back then in the DA's office, I mean, my client is just prejudiced because of those decisions. Because, again, everybody waited all these years, and now we have players that are co-conspirators that are just dead and can't, deny participation. And so with that, we submit, Your Honor.
Thank you so much, Mr. Duane. Okay, I'm going to take your arguments in turn. First, the corpus electi argument. I am going to consider this on its merits, given the Supreme Court's guidance in Diane versus State. I think that it's better to at least hear it on its merits. Corpus electi requires that there be corroborating evidence to support a confession. In a homicide case, the Supreme Court, as we both said, indicated this to be satisfied by proof of death by criminal agency. So I think maybe an example makes the most sense to explain what this concept means. For example, I confess that this morning, as I was driving to work, I killed someone on 30th Avenue. All right, now let's say there's no body ever found, there's no video, there's nothing. It's only my statement that I killed someone that makes this crime exist. However, here, that is not, in this case, that isn't the case. There is corpus electi because Mr. Shakur was shot and eventually passed away from his injury. An autopsy was completed. His death was determined to be homicide by gunshot wound. And ultimately, it's a situation where the crime has been established. That's that it's been a murder occurred because of the body of Mr. Shakur. So I will deny it on those grounds. Regarding the pre-indictment delay argument,
he's done. He's going to trial. She just denied Keefe D attempt to dismiss this case. She just denied it. The judge just denied Keefe D attempt to dismiss this. They're going to put him in prison for the rest of his life based off his own statements. Let me say this again, and this is going to go viral later on today. Y'all not catching this now, but it's going to go viral, bro. They have used Keefe D's interview where he spoke about an open murder. Open murder. And now he's probably going to go to prison the rest of his life. He just tried to get this thrown out. The judge just said, nope, we ain't throwing it out. The prosecution tore him up. Said that proffer agreement, nah, I ain't got nothing to do with this. Nope. And y'all smash the like button, man, and share this video, man. Let me play this and get through this.
Makes the most sense to explain what this concept means. For example, I confess that this morning, as I was driving to work, I killed someone on 30th Avenue. All right, now let's say there's no body ever found, there's no video, there's nothing. It's only my statement that I killed someone.
Now listen to what she said. Y'all gotta listen to what she said now. She's saying that, Keefe D saying, it don't matter what I say. It ain't no evidence. It ain't nobody here. It ain't no gun. It ain't no... Man, the judge is telling y'all that no. That's not how this works, Lebowski. Your ass is still going to prison. Or you still going to trial. You know what I'm saying? Because, and this, she explains why, that even though there may not still be no physical evidence, that his testimony alone could send him to prison for the rest of his life. Now listen to what she's saying, because what she's saying is very important for all you young fellas out here that's listening.
As I was driving to work, I killed someone on 30th Avenue. Corpus electi requires that there be corroborating evidence to support a confession. In a homicide case, the Supreme Court, as you both said, indicated this to be satisfied by proof of death by criminal agency. So I think maybe an example makes the most sense to explain what this concept means. For example, I confess that this morning, as I was driving to work, I killed someone on 30th Avenue. All right, now let's say there's no body ever found, there's no video, there's nothing. It's only my statement that I killed someone that makes this crime exist. However, here, that is not, in this case, that isn't the case. There is corpus electi because Mr. Shakur was shot and eventually passed away from his injury, and an autopsy was completed. His death was determined to be homicide by gunshot wound, and ultimately, it's a situation where the crime has been established. That's that it's been a murder occurred because of the body of Mr. Shakur. So I will deny it on those grounds. Regarding the pre-indictment delay argument, as you both cited, like the standard that's laid out federally in People versus Nelson, I'll use that standard. A delay in prosecution that occurs before the accused is arrested or the complaint is filed, so we're looking at a pre-indictment delay argument. That could potentially constitute a denial of the right to a fair trial and due process of law under both state and federal constitutions, and then determining whether prejudice to the defendant occurred according to the arms of the defendant as the justification for the delay. Here, it's clear that some of the witnesses are not deceased, and there is definitely evidence that has been lost. However, I do find there is a justification for the delay, and a pretty significant one. Uncovering information on Mr. Shakur's photo was ultimately known to be cast. There was the interview in 2009, but it's clear that there was, at the attorney's suggestion, Mr. Davis at that time was not getting full information. He was sort of trying to obscure information and make it very general so that he would not be in charge of murder, as his attorney indicated. It was not until ultimately the Compton Street Legends book was released in 2018 that Detective Vaughn then sought to establish the words in the book are actually defendants and to corroborate these things. The prejudice of the death of those words that have been identified had already occurred at that time. Additionally, they took the next several years to gather that evidence and ultimately led to the June 2023 search warrant of the defendant's residence. After that search warrant was executed, then the grand jury indicted the defendant after several meetings. In September of 2023, the defendant has not provided any evidence to establish the delay was intentionally done to gain a tactical advantage, like the prosecution related in bad faith. I don't see that the state really does gain any sort of tactical advantage here. I still think, it's a good enough battle for them given what they have. And ultimately, they can't get complete justice for Mr. Shakur because of the deaths of those other people, including Mr. Anderson, who's the alleged shooter in this instance. And so I ultimately don't see that this is a situation where the state really got any advantage by delaying, and in fact, is themselves hindered.
All right, so she says, this is what she says, and this may have been a little bit of news for Keefe D that he needed to hear. She says that she still thinks it's an uphill climb in the case for the prosecution against Keefe D, but she's not dismissing the case. He's going to have to go to trial. She's saying and she said there'll never be full justice because the other guys are dead. So there'll never be full justice for, the murder of Tupac Shakur. Now, here's the thing. When they go to court, this is where, it's going to get shaky. Physical evidence. And the whole case, in my opinion, is going to be built off of whether or not that proffer agreement stood and whether or not Keefe D's statements in those interviews, is going to put him in prison for the rest of his life, or is eligible to put him in prison for the rest of his life. Being that there's a murder that happened with Tupac Shakur, he confessed, blase, and blase. You know what I'm saying? So definitely let me know what y'all think. Appreciate all of you guys that is tapped in. Y'all know what it is. And I'm gonna holler at y'all, man. Y'all know what's up, man. All right, you guys. So we appreciate everybody that popped in, supported this video. Make sure that you guys shop our merch. We got that new A-Weapons merchandise right there below this video. All you gotta do is look below. The links will be pinned at the top of the comment section as well to get the merch, to donate, support the channel, and subscribe to our podcast show. You'll see all those links pinned at the top of the comment section of this video. And we appreciate everybody that supports this channel and our networks. Also, that straight drop weight loss formula. Go to the website. You guys will see that. A link for that will be pinned at the top of the comment section as well. Go right there for all of your weight loss needs. Straight drop weight loss formula. We have a lot of testimonials on the website. You can go to www.str-8-drop.com and get you some of the weight loss formula today. Take your weight loss serious. Get in the gym, work out, exercise, and do what you got to do to stay on point. We appreciate everybody that's been locked into this video. Again, all the links are pinned at the top of the comment section below. Salute to all of y'all. And again, we appreciate everybody who support what we doing over here.